folks here. They might want to be a part of this.
Yes, and David's not here too. Where'd he go?
She was probably hunting her coat. Okay, folks, we'll resume. I think there's a couple more folks that had indicated they wanted to be considered for standing. Mr. Proctor, you come up.
My name's Jim Proctor. I live at 328 Boys Camp Road. I am not obviously a property owner near this parking lot. I was the real estate broker that introduced the adjacent property owners, David and Charlene Kohler, to the property they own now. And in that regard, I would like to say some words in their behalf. They want to speak, I believe, on their own, but it does strike me that when they bought that property, it was clearly everything on their side of Charlotte Drive zoned residential, and the assumption was everything on that side of Charlotte Drive would remain residential.
Mr. Chairman, I'm going to enter an objection here. Mr. Proctor, are you seeking to intervene, become a party in this matter? Because I think right now we're at that stage where we're looking at the issue of standing, and there'll be, I imagine, a chance to testify later in the proceeding.
My understanding of what he is indicating is he's providing a blanket for Ms. Kohler, who's about to come up and testify about her opinion of standing. So it may have taken this out of order, but he's not asking for himself individually. He is speaking to assist her case.
May I say something? If we're only talking about standing and I'll be allowed to testify later, then I will sit back down.
If someone calls them as a witness for some purpose in this case,
Then he can come as a witness, right?
yeah, if it's
Okay.
got- yeah.
Thank you.
Yeah, I think, Ms. Kohler, you can always ask him to, you can call him if you'd like.
Hi, everybody. My name is Charlene Ann Kaiser Kohler, and I reside at 105 Sandalwood Drive, Lake Lure, 28746. I found out about this last night, letter I received in the mail, which had gone to a previous address, which I no longer own in Florida. I believe my husband and I's issues with the parking lot is that it would be right across the street from our property. One, that it would impact the value of our property. Our property values would go down. The other thing is we have a well pump house, which is directly across the street from said location of parking lots, which we have concerns of chemical runoff and impacting the well pump house, which feeds 6 other families beside ourselves. Well, six total, 5 others, and then my family. The other thing is, I was told when we bought the property from Mr. Proctor that it was residential, and because I queried on that. And we moved up here because of the beauty and the tranquility and the peacefulness of the mountains. That's what attracted us to Lake Lure, is because that it was a small town and there wasn't a lot of riff going on, a lot of people coming and going. So I believe that that would be a direct impact on our lives. You know, people coming and going. I've been walked down to the lodge several times with my small dog, and like another lady had said, the road's narrow, it's winding, and with normal people that go down there, they don't observe the speed limits. So somebody who doesn't live here, they wouldn't know to drive slowly. And they have a substantial parking lot already. I don't understand why they would need to take up 8.5 acres and put a parking lot into a residential area. I own property in Florida that the condos, and then there was a parking lot, and I had a very hard time selling. I don't plan on selling my property, but I don't want my property values to go down in case something would come up to where I would be forced to sell my property.
Okay.
Mr. Kelly, can I ask a question?
We're all gonna ask questions. So, can we ask you some questions now?
Sure.
All right. You can start down there, Mr. Owensby.
On this, do you have a copy of this plat here?
No, I do not, sir. Okay,
If
my
down there-
property I own
Down there
from
where
all the
the-
way down
She's gonna tell us
Charlotte
where it's at.
to Wandering Wandering Lane. Okay,
I'm better at maps than most people.
I own this property right here.
My question
No, right
is,
here.
based on the two red dots.
Oh, right here. Okay, I own this whole property right here. Charlotte to Wandering, Sandalwood
There.
Yes.
to Windsong. I own that whole pie shape, which is directly across the street from the fire department.
Mr. Chairman, just
This
maybe it'd
one.
help for the record if Ms. Kohler would maybe put a K on this exhibit.
Oh, okay, yeah, I can do that
We
for
will
you.
mark it.
I put
Yeah.
an X, but if she wants to put, if she
Yeah.
can do it on, I put an X on all of theirs, just so that we can have this
Okay.
one. Craig, so you can keep yours. I'll
This
give
is-
mine up.
All right, this is all my property.
Yep.
And the well pump house is right there.
Mr. Chairman, she put a K on the one exhibit C that was to our application of her property, and she's indicated where the well house is also on that.
Oh, okay, 1646116.
And you do have a home on that piece of property?
Yes, my tax number is 1646116, sir.
And that was 185 Sandalwood is the street address? Is that correct?
105.
105.
105 Sandalwood Drive.
There. I mean, and I'm just marking where she's marked.
That's all my
Any
questions,
oth-
that's all my
Any other
questions.
questions for Ms. Kohler?
None.
Someone asked you if there's a house on your property.
Yes, sir, I have a cottage.
I didn't hear the answer, so.
Yes, sir, I have a
Okay.
cottage.
All right.
Yeah.
That's it. Anybody else have any more questions?
When did you buy? How long have you owned the property?
May of 2014?
Just do that.
That's it. Yeah, May 10th of 2014. So I've been here a little over a year and a half, and I'm enjoying it immensely.
Are you full-time here?
Yes, I am, sir.
Okay.
I'm a full-time resident.
All right.
And the date of the notification, you said that went to an old stale address? Is that why you got the
Yes,
notification so late?
My husband went and paid the taxes in Rutherford County, and he changed the address to the 105 Sandalwood Drive, Lake Lure, 28746. And I don't know, somebody didn't get the message right.
Okay.
They didn't change it. They still have us down as 4201 South Ocean Boulevard, Palm Beach.
Okay.
We do not own that property. In fact, that was the property I had such a difficult time getting rid of because there was a parking lot right there where the condo was.
Any other questions for Ms. Kohler?
And that is, yes, that is your house that is shown right near the corner of Sandalwood and Winsaw.
Yes, sir.
Okay.
And also, my neighbor who lives directly down the street on, I believe it's Winsong at the end, Melissa King, she's an EPA person. She also said that she's very concerned about the chemical runoff damaging the well pump house because,
We can't take any other,
Okay.
any
Well, I
other
just-
information from other folks.
all right, thank you very much.
You're welcome. Yep.
I do have a question.
But we got, let the other attorneys ask questions.
I'm sorry.
Mr.
Ms. Kohler, you said, I think you referred to the parking lot as 8 some odd acres.
What the man, I wrote down what the man said, 8.51 acres of parking lot. That's a huge parking lot.
Ma'am, he was referring to Ms. Doolittle's property, not to the parking lot. The
Oh,
testimony,
my bad.
of course, is the Exhibit C to our application is the parking lot are these 2 parcels that are identified with red here and here. And I believe you said your property is directly across the street from those 2 pieces.
It is, and it's still a lot of land.
Thank you.
The parking lot would still be a substantial piece of land.
Okay. Mr. McGuire, like questions?
Very few questions. Does your cottage face the parking lots?
I have visual view of that area, yes, sir.
From the side or back of the cottage?
The back.
Okay. And do you pass these parking lots when you drive to your house normally? Or is it?
It depends on what way I enter my house, yes. If I come up wandering, yes, I would see them every day.
Is that the way you normally come in?
Yes, it is, sir.
And your concern has to do with chemical runoffs?
The chemical runoff and also the depreciation of the value of my property.
Is it fair enough, do you know what chemical you're afraid of running off?
Whatever chemical they use to create the parking lot.
You mean when they do the paving, you think there might be some?
Yes,
chemical?
yes,
And is your concern is about your well pump house?
yes,
I take it that's well built?
yes,
Okay. And you acknowledge this is an overflow lot? This is to be an overflow lot?
yes, and I don't understand why they need an overflow lot. They have a substantial parking lot down at the lodge now as it is.
So you don't have any idea how much use, whether it be a good bit, a lot, or a great, or whatever use will be made of this overflow lot? Is that fair enough?
I don't think any of us do.
Okay. Now, that's all I have.
Okay. Mr. Egan, you have any?
Thank you very much.
Thank you.
Mr. Proctor could speak on my behalf because he is the person that did sell us the property.
Okay.
Thank you.
Yes,
If he's
ma'am.
gonna testify about opinions, I think he can, if he's going to attempt to give her standing. I mean, we're talking about whether she has standing to present her case before this board. But she didn't appeal, she's not a party. I mean, if the board wants to let her come up and testify, and they believe that she has standing to do so, the board can vote on that. But to call Mr. Proctor as a witness, just to offer lay testimony, I don't know what he's gonna offer. But the board would have to make that determination if they wanna hear about him, specifically related to whether she's got standing to appear and present a case before this board on this appeal issue.
So if everybody understood, what, Ms. Kohler's not a party to the appeal, being represented by Mr. Justice, correct?
She is not, at present, my client.
Okay. So so we're considering her standing based on the fact that she's a joint property owner and, and the facts that she gave us there. So,
I don't know, personally, I don't know if Mr. Proctor would garner any information that would change my opinion personally.
well, let's decide on her standing first, okay?
Yeah, and that's what I'm saying, in terms of her standing.
Right. Okay. Ms. Behringer?
Start on that end. I'm a little bit confused and I want to read something from the North Carolina statutes.
I can go ahead.
Mr. Dolan, start on that end, okay. Go ahead, Mr. Hornsby.
Well, based upon what I ruled on, standing on the other, she is awful close to the property, and I would think upon that, she would have standing by being that close. So I vote yes, that she does have standing.
Okay.
For the same reasons, I think since she is adjacent to the property for the parking lots, she does have standing.
All right. Mr. Butts?
I'd say the same thing, yes, she has standing, given that being a adjacent property owner was sent original notification, that in standing in this case, she does have standing. She's impacted differently than the general community.
All right. Ms. Behringer?
Yes, she does have standing. I was confused the fact that she's not part of the appeal. But yes, she certainly has standing with the proximity of her property with the parking lot.
Okay, and I also will vote that I think she has standing in the case as well. So, is that everyone that stood up to be recognized that wanted to be considered for standing in the case? I think it is, unless I missed something. All righty. Need a second to get my notes together here and.
Mr. Chair, I believe that there's been a motion filed by, a joint motion, I believe it is, filed by the town and Mr. McGuire on behalf of his clients. I deem it would be appropriate to hear that motion before the public hearing's opened up and testimony is offered in regards to this.
Okay,
Mr. Chairman, members of the board, we have filed a joint motion to dismiss, copies with your council. I'm going to spend just a little bit of time going through the history of the case. I know we've been here a long time already, but I think it might be helpful as far as understanding that what sort of advice, what's something that's being called a determination by counsel for the appellant, to understand the context that came from. The appeal springs forth out of the context of the town's processing and consideration of an application to rezone the lodge on Lake Lure from R1 residential to R3 CD resort residential conditional district. Conditional districts, and one of the reasons I want to spend a little bit of time on this, they're new to Lake Lure. The regulations were amended just a few years ago. I think this is the second one that the town had, and I don't think this board has considered anything having to do with a conditional district. These districts were authorized by the general statutes a few years ago. They are districts with conditions voluntarily added by the applicant and approved in a legislative decision-making process by town council. In essence, conditional district zoning results in a zoning district with its own unique set of development and design standards. Typically, an applicant will voluntarily limit the uses that can go on the property, and agree to be bound by a specific plan of development, which has happened in this case. At the same time, the applicant, the lodge on Lake Lure, may request that certain standards for the zoning district be modified in order to accommodate the proposed development. And both of those dynamics occurred in the town's processing of that application.
Mr. Chairman, I'd like to go ahead and raise a groundwork for an objection here. What Mr. Egan is doing is he's providing facts, right? He's an attorney. He cannot provide facts. If he wants to introduce Mrs. Spicer as a witness to provide facts, and then from those facts make an argument that is consistent with his motion, that would be fine. But he is starting off talking about factual things, and we've not even gotten into the merits of this one way or another. We just had testimony about standing. So I do think it's a little premature for him to start throwing out facts at you that are not in the record.
On the contrary, they are in the record. The record on appeal, which was sent forwarded by the zoning administrator, her responsibility under regulations, these matters are part of that record.
Mr. Chairman, I haven't had a chance to even rebut or ask her any questions about the record. It's not the record until ultimately we're done with saying, here's the record for you to consider. I have no chance to talk about what credibility she has or whether or not her factual spin is really true or not. So the fact that you've given papers to this board previous to today is not quote unquote the record.
That's the record on appeal. That's what the statute and that's what the regulations call for. She certified that to this board. So, I mean, the basic issue that we have here, I'm trying to give you some context, but Mr. Justice has filed an appeal. That's part of the record. I hope there's no objection to that. In that appeal, Mr. Justice says that the zoning administrator made a determination, and he is appealing that determination to this board. It's clear from the record that you have before you that was certified to you by the zoning administrator that there was no determination made at any point. And in fact, it would have been certainly beyond her administrative responsibilities to do so. It was town council's decision to make in a legislative decision-making process in conformance with the town's zoning regulations.
Again, Mr. Chairman, I'm going to object, and I do believe that the record is not complete until we close the hearing, and then you have a record. Normally, with all due respect, being the applicant, I present my case, and then the town would present their rebuttal in their case. And so there's no record here because the public hearing hasn't been closed. You are taking what Sheila has sent in advance and saying that is the record. He is offering up facts about what town council ended up doing. And I have a lot of questions of Mrs. Spicer about that. And so I do think it's premature for Mr. Egan, with all due respect, to jump ahead and put the cart before the horse.
Well, these matters that I'm talking about were included in the appeal filed by Mr. Justice on, I think it was December 29th. That is a part of your agenda packet. You can certainly make a determination as to whether there's a basis for an appeal here, whether there's something that this board has jurisdiction over based upon the appeal filed by Mr. Justice on behalf of his clients. And I would say that you can certainly hear this and make a determination. I think it might save everybody a lot of time to do that. Or if you want to, you could wait and we'll raise it as a motion for a directed verdict later. But I do think that there's ample evidence in the record that you have before you as part of this agenda packet to make this determination.
One last thing, Mr. Chairman, as part of procedure, what he's talking about is to save time. If you were to somehow decide that he has corrected that right now and end it, I would have the burden to go ahead on with my case so that a court looking in on this could determine whether I was prejudiced by your decision. So I still would have to go through all of my questions and get to the end of this road before we could all leave here today. So there's not any economies of scale, judicial efficiency with a motion occurring before the record's even complete.
If I can chime in, just on behalf of the Lodzer,
I think what I would agree with Mr. Egan, that before you hear evidence to decide an issue, it makes sense to see whether there's an issue to decide. And the appeal in this case, for you all to hear it and hear evidence, there has to have been a determination by Ms. Spicer, and there wasn't a determination. So there's no reason to hear evidence whether or not you want to overrule the determination when no determination was made. So I would certainly disagree with Mr. Justice. If there's no issue for the board to hear evidence on, I'd see no reason why you'd want to hear evidence. And their whole appeal assumes that Ms. Spicer made a determination, a decision. And I think, as you'll hear, she didn't. She merely sent an email saying what the requirements was. She made no decision, therefore, there's nothing for you all to hear. There's no issue correctly or appropriately or rightfully in front of.
I'm able to dispose, I guess, of this real quickly, which is, if you look at my application, what we've appealed is a determination made by her that on these two R1 properties, a commercial parking lot supporting the lodge would be a permitted use. That is what we understood from a meeting on December 15th, is what she said as a determination. If you look in our application, there is a transcript from that meeting where Commissioner Moore asked her the very exact question, where she said, I have determined that a commercial parking lot would be allowed on those two pieces of property. If she wants to say today that she hasn't made that determination of whether commercial parking lots would be allowed, then I guess they would be right, and we would formally submit to her a request to make a zoning ruling as to that, from which, if it was adverse to us, we would appeal again. So I don't want to waste anybody's time. If I have misunderstood her, then I apologize. But if she's determined that a commercial parking lot is a permitted use in the R1 districts in question, then we have a right to appeal it.
Yeah, and if you look at the transcript, I guess on page 117 that Mr. Justice is referring to, nowhere in there does Ms. Spicer say she made a decision. And actually, Craig is using the word determination. The statute says decision. A decision is something which is akin to a verdict. It's, you know, the purpose, and this is argument now, it's not evidence. The purpose of these appeals from zoning administrators is to give people their day in court, an opportunity to have, to review such a decision. And so therefore, you have a time frame. The decision's rendered, there's a time frame then to appeal that to the Board of Adjustment. There was no such decision made here. The email, which is in your agenda packet, you'll see from looking at that all Ms. Spicer did was, once she learned about the off-site parking, that she advised the lodge on Lake Ward as to what the zoning regulations said, what they say about off-site parking. And also advised them that another part of the regulations would allow them to ask for those terms to be modified in the conditional district zoning process. That's all she did. She didn't decide that parking is a permitted use in a residential zoning district. That decision was made by some distant past town council when they put the language in 92-103 into the zoning regulations, allowing, some courtesy would be appreciated.
I'm sorry.
Thank you. Allowing parking to go into residential zoning districts under certain, specifying what those regulations would be. That's all she did, was tell them about that. And then, when it got to the meeting on the 15th of December, in response to questions by Commissioner Moore, she basically reiterated what she had done. She, again, if you can find the word decision or decide in that transcript,
Can I ask you specifically where you're referring to that on this?
Yeah, it's, on the transcript portion is, her testimony is page 117, 118, I believe. And there's nowhere in there is the word decide, decision, determination, appeal.
Mr. Justice, can you tell us where that is in this,
Yes, attached as Exhibit B to the application is a portion of the transcript from the December 15th, 2015 meeting. On page 117 of that transcript, Commissioner Moore, and I'm assuming there's no objection that this is in fact the transcript, asked a question about the parking lot in question, of whether it would be allowed under the regulations. You can read for yourself that the answer that appears would be yes. And we took it that way when she announced that.
where is that specifically?
So the zoning regulation, so Mrs. Spicer down at the bottom of the page says, so the zoning regulations and the parking requirements has provision for allowing off-site parking. It's section 92.103C, in the extension of parking space into a residential district. And so I can read the whole thing, but it's ultimately, it was our understanding from that meeting that she had made a determination that the ordinance would allow for a commercial off-site parking on these two parcels based on section 92.103C. And where we were about to go through the merits of 92.103C, which would not allow commercial parking on these two parking lots. And when Mike says, well, the town council made a decision, the town council adopts zoning regulations. I have a certified copy of it. It is up for the town administrator to then interpret those regulations, that ordinance, and say, for instance, whether something is allowed or not. It appeared to us that she was saying that nothing else more required, that as we sit here today, this Board of Adjustment hearing, commercial parking lots would be a permitted use on these two parcels. If they simply said, Mr. Chairman and Board, that that's incorrect, that she has not made a decision or a ruling that commercial parking lots would be allowed on those two parcels, then we would be premature. And we would basically dismiss our case without prejudice to refile if she so later made that call. But think about this, and you can see it in their motion to dismiss. We have 30 days to appeal to this board when we believe there's been a ruling. That's not a lot of time to sit there with a lot of guesswork about what's happened. And so when we hear something on December 15th, 2015, as it's been testified to, that she has made a determination that commercial parking lot would be allowed in these two R1 districts, we said, oh, she has made a decision and we need to appeal it within 30 days, which we did. Again, if we're wrong, then we apologize, we'll withdraw our appeal. But the simple question to ask of her is, as we stand here today, with all things zoning in terms of the regulations that are in place in this town, would commercial parking be allowed on those two properties in support of the lodge? If she said, I don't know, I haven't made a determination, then I will take that as her sworn testimony and we will walk away without prejudice. That's the simple question to ask.
Maybe I can add some clarity to the issue that's being presented by the two parties. In order for this board to hear an appeal from the zoning administrator, that's what confers jurisdiction upon this board, I think. And I'm just guessing. I'm believing this motion to dismiss says, first, this board doesn't have jurisdiction to hear an appeal. The statute and the town's ordinance, I just was looking, they basically say the same thing. It says the Board of Adjustment shall hear and decide appeals from decisions and I emphasize decisions, because that's what it says, of administrative officials charged with enforcement of the zoning or unified development ordinance. The statute itself tells you what a decision is. And it says, as used in this section, the term decision includes any final and binding order, requirement, or determination. So a decision is any final or binding order, requirement, or determination. This board, I believe, will have to make a determination, and there's a lot of arguments about the record. Your ordinance says the same thing again when there's an appeal. It just says, the official who made the decision shall transmit to the board all documents and exhibits constituting the record upon which the action appealed from is taken. That's all it says. So this board can consider the packet that was delivered to it as the record and can use that in its determination of whether there was a decision made. And if this board wants to hear testimony from anybody about it, I believe this board has the authority to ask that they hear testimony, or this board can just look strictly at the record and ask for arguments presented by either side of the information that's in here to see if this board has jurisdiction to even hear that appeal. That's the first issue. Do we have jurisdiction to hear the appeal? And I think it's mandated by the statute. And I can read it to you all again, what a decision is, if you'd like. But
Yep, I'd like for you to read that again.
So, the Board of Adjustment shall hear and decide appeals from decisions of administrative officials charged with enforcement of the zoning ordinance. The term decision includes any final and binding order, requirement, or determination.
Can I ask a question there?
Yeah, of me? Legal question? Yes.
What, defining, binding.
And I thought you'd ask that. I pulled a case that talked a little further about what a decision is. It's Meir versus the City of Charlotte, 206 NC App 471. And it specifically held that a decision must have some binding force or effect for there to be a right to appeal. So I think the board's going to have to make a determination after that law, off the law. Was there some binding force or effect to whatever Mr. Justice says, whatever Mr. Justice argues that Sheila made? Was there some binding force or effect? And if there was, then they've got a right to appeal. If it wasn't a decision, then I don't know that this court has jurisdiction to hear the appeal, because there's no reason to appeal. It wasn't a decision.
Everybody understand what he's saying?
No. Ask me.
Not really, not really.
Okay.
Well, we have to determine, if someone correct me if I'm wrong, I'm sure they will, if Sheila made a determination,
A decision.
a decision, a binding decision. So when Sheila's is somewhere that it says that she made a binding decision, and what she had to say was the final say-so.
Well, do we have the right to ask Sheila that, or do we have to make that determination before we get to hear her?
If the board opens it up to question Sheila, I think everybody gets an opportunity to question Sheila. This board should look at what was transmitted to it
Okay,
to see if there was,
If we can make the decision based on what has been filed and given to us, we need to make our decision based on that.
okay.
It's my opinion. Okay?
and I think that there's legal arguments that they could make based upon your ordinance says it's the record. And so I'm not changing that the person the official who made the decision shall transmit the board all documents and exhibits constituting the record upon which the action appealed is taken from. There's been a motion made that this court doesn't have jurisdiction because there was no decision from which to appeal. And that would need to be included in the record.
Mr. McGuire?
If I may comment, I think Mr. Justice has indicated where he thought what he heard was a decision, but I think if you read, it's basically one long paragraph. You will not find a decision in there, certainly nothing that is final and binding. She's merely commenting on what the regulations say. You know what a decision is. A decision is when someone says, I'm telling you this is the way it is, and it's final. You don't
Binding.
It's binding, you know, and it's not there. And I just also like to comment for the record, this is an historic occasion. Mr. Justice has apologized to the board. And,
That's rare.
That's rare. But I
I
think.
don't know how much more you can get than rare, really rare.
I would go with really rare, but I think that his apology tells you that he may have thought there was a decision here, but I don't think you can read that even in any stretch and say this is a decision. So I would.
Well, that's why I was looking for that word.
Yes, sir, it's
Here.
not in there.
Well, let me clarify. I said if Mrs. Spicer would answer the question, and I, with all due respect, she's right there, and the question is, because the question posed to her was, does the property, these two parcels, have to be included as part of the rezoning application so that property owners get notice that that property will be rezoned together with the lodge in order to allow the commercial parking? And her answer was, rezoning, I don't think we have to rezone anything because I think the town council can just waive it without rezoning the property under section 92.103. And if you look in her email that she's included in the record, and all due respect of what the record is, I have no control over what she sends up, none whatsoever. So you think about due process, about saying the record is done based on a zoning administrator having complete control of saying, here's the record. But in her email, she is setting forth that basically, again, that without rezoning the property, that town council can just waive zoning requirements for these two parcels, even though they weren't part of the rezoning application, that somehow they have that authority. So that's why I posed the question to you today, Mr. Chairman of the Board. Today, as we sit here, will commercial parking be permitted on these two parcels? Has she made a decision about that? To cut through all the cheese and shade, that is the question. Has she made a decision that commercial parking today would be allowed on those two pieces of property without anything more in terms of zoning changes? And if her answer is, I haven't made that decision, then that's when I'll apologize as really, really rare. But I think she should answer that question, because that cuts through all the smoke.
Well, my personal opinion is that I think the first thing we have to satisfy is this motion to dismiss. I think we have to satisfy this motion to dismiss. As the chairman of this board, I certainly do not want us to make a mistake. I do not want us volunteers here listening to this with you guys this is your profession. I do not want to make a mistake that we make a mistake here. So I think the first thing we have to determine is, do we have the authority to make this determination? And I think my opinion is that's where we have to start. And then if this board votes in majority that we do have them, then we're off down the road of testifying and hearing what everybody has to say. And can I ask you, sir, if that's accurate?
If that's the way that the board wants to proceed forward, the answer is yes, it's accurate. I think the board needs to pay special attention to just what the statute says about appeals. And if there hasn't been a decision made, then it can't be appealed. This court doesn't have jurisdiction. If there was a decision made, then it can be appealed. If the zoning administrator made a decision, then it can be appealed and conferred upon this board is jurisdiction.
Comments from anyone else?
I don't know if, Mr. Chairperson, I don't know if everybody's done indicating as part of what was sent up to you all, if there's anything else that they'd like to add to that. I mean, if there's other legal arguments that they want to make or.
We didn't hear the rest of this.
Right, I think I think there's two parts to it, and the next one is the appeal was not filed in a timely fashion. That would assume that there was a decision made, and then if the board says, yes, there was a decision made that could be appealed, then their motion goes on to say that the appeal was not timely filed, which would mean inside 30 days when the decision was made. But I think this board has to decide first, was there a decision made that can be appealed to give this board jurisdiction?
Does anyone have another question of our attorney? Can we have some discussion, or do we need to have discussion? Does everyone feel like they understand exactly where we are here?
I know where we are, but I don't know where we are.
In reading and rereading this several times, she basically is answering Mr. Moore's question with what the regulations state. She is not confirming or denying what they're using it for. She's answering his question as to what he wants to know what a parking requirement is, and she answered what a parking requirement is. She didn't answer, yes, we're going to make this a parking lot.
Okay, anybody else have comments?
If you'll go ahead and read all the way down in that, on her statement that continues on to 118, it says that it's up to the town council to make the decision.
Yeah, that would be, I think somebody has made a decision there's a parking lot there, so the question would be who made that decision? Whether it was a staff decision or a town council decision, is what I'm getting from this.
That's right.
So, based on what I see here, evidence-wise and that type of thing, we've got to make that, if there was a decision made.
If she would make the decision.
If it was a staff decision or a town council decision, because there is commercial parking proposed for those two things, correct? I mean,
That's the way I understand it.
Right.
and as a Board of Adjustment, we serve as the go-between between the citizens of the town and the staff of the town as kind of the mediator in that respect. So we do have a burden for the parties that are involved in the case as well. So just somehow it's decided that there's parking there, so that's the question, is who decided that parking was there?
If I might, Mr. Chairman, just speak a little bit more and finish discussion on our position on this motion to dismiss. It may help your deliberation, it may not. If I could, just finish that, we sort of got in a repartee and didn't. So, and I think now we've talked through it pretty well. I think it's patently obvious from the text of the email and the transcript provided by Mr. Justice that it contains no conclusion or judgment or binding determination or decision, as those things are talked about in the general statutes and in the town's regulations. And Ms. Spicer, it's clear, merely advised the lodge, that's what we're going back to the email, as to provisions of the zoning regulations which were relevant to its proposal to place off-site parking on the, what I call the ancillary property, the two lots in question. She did not decide to approve the off-site parking proposal, and in fact, she had no authority to do so. She did not determine that a commercial parking lot is a permitted use in an area zoned R1 residential. Again, that wasn't her authority. That was a decision made by town council, and it's embedded in section 92-103C of the zoning regulation, which I would ask this board to take official notice of. And this was all part of a process. That's why it started to go through the process of conditional district zoning, which ends up with town council making a decision. Town council did make a decision. They decided to rezone the lodge property from R1 to R3 CD. And in the course of that, they decided to modify the standards for off-site parking in a residential district, to allow for the proposed off-site parking, by the lodge. Only town council could make that determination, only town council could make that decision. It would have been, inappropriate for Sheila to make it, she didn't have the authority or the power to make it, it would have been unlawful for her to make it. Just as it would be unlawful for this board to review a decision of town council. You don't, that's not in your charter, that's not in your powers. You can review a decision of a zoning administrator, but you cannot review the decision of town council. That's as it should be. And we do cite a case there, Simpson versus the city of Charlotte, that stands for that principle. It was a decision of the governing body of the town of Lake Lure. That's what really is before you. And it would be inappropriate and indeed illegal for this board to review a legislative decision of town council. And I think at that point I'll stop, maybe not discuss the second ground until, if that's all right with the board, until the board decides that first ground for dismissal.
Thank you, Mr.
Yes, sir.
Sheila Spicer, from the email of October 29th, 2015, that we were not aware of, she sent this up as part of the record. And in the transcript of the question asked by Mr. Moore. the
What
question-
page are you on now?
Well, this is in the transcript on page 117, the question.
Okay.
The question is, does town council have the authority to allow commercial parking on these two parcels that are not part of the rezoning application? So hang with me. When you have a rezoning application, you put PIN numbers on there of the properties where you're changing the zoning requirements. You send out to the public notice that those are the PIN numbers and properties that are being rezoned. Whether the map gets changed or the regulations for the particular district gets changed, then the public is aware that here's the rezoning application and here's the properties that are included in that. Those two parcels were not part of the rezoning application. They were not rezoned. Mr. Egan in the transcript even says, well, they weren't even rezoned. So he was asking the question, well, shouldn't they be included as part of the rezoning application? Don't we have to notify the people around those two parcels? And the answer was no. You can, through the application of the town of the Lake Lure Lodge, for the one property that's 1,400 feet down the road, you can just simply waive a use standard, a standard. And that's just simply wrong. If she meant, and that's why I said to cut through the smoke and simply ask her the question, today as we sit here, would commercial parking be allowed on those two parcels as a permitted use? To ask her that. Because if she says, well, yes, the town has already decided that through the council, then we do have a decision that she's made. That town council can somehow, outside of rezoning, just simply waive the fact that you're not supposed to have a parking lot in R1 unless it adjoins a commercial district, which these two parcels do not. And so that's it in a nutshell. That's why I say, if you just ask her the simple question, as we sit here at the Board of Adjustment, is commercial parking permitted on that property? Has she made a decision? If the answer is no, I haven't made that decision again, then we're premature. And what would happen, Mr. Chairman, is I would send a letter to her and ask for an official ruling of whether or not what was shown on the town council plan presented in terms of a commercial parking lot, would that be allowed on these two pieces without going through a rezoning process for those two pieces of property? And I would ask for official zoning ruling. And we would get an answer, yay or nay. That's what I would do, in reliance on whatever the testimony, and I hope someone will ask you the question. Today, as we stand here, would commercial parking be allowed permitted, without anything more.
Well, one of the questions that Mr. Justice asked was, would like to ask Sheila was, did she make that decision? And I think Sheila would say, no, she did not make that decision. And it's clear that, and even in Mr. Justice's comments, it's clear that town council made that decision. And Mr. Justice's clients have a remedy, a declaratory judgment action, and they can challenge town council's decision to rezone the property and its effect. And in that can challenge the list of standards and conditions that went along with it, which allowed the extension of parking into a residential area.
I implore this board to ask her the one question, which is, as you stand, if it's part of the motion to dismiss, Mr. Chairman, in terms of has she made a decision, is to ask her, as we sit here today, have you decided that commercial parking is a permitted use on these two parcels? If her answer is, well, town council decided that, what that means is that she has determined that there doesn't have to be a rezonning of that property. That through what they did with the lodge, that was enough for them just to simply waive it, and that in fact, commercial parking would be allowed. So that's why I'm imploring you just to ask her the question, is today, has she decided whether commercial parking is a permitted use on those two parcels? And again, if her answer is, I haven't decided yet, then we are premature.
If I can just finish commenting, I think the question is there a decision in these 2 pages? And I didn't even, it sounded like Mr. Justice said Commissioner Moore asked for a decision. I don't see him asking for a decision, and I don't see a decision in there. I just asked you to read that, and if you see a decision in there, maybe he's right. But he has the burden of proof to come to you all and say this jurisdiction for you all to appeal a decision, but he hasn't shown a decision. He's got to show a decision, and these 2 pages, read them as many times as you want, but there's no decision.
You're right. I think I have a lot of burden of proof, and my burden of proof would have been to ask in this context of, has there been a decision? I would ask her the one question that I'm asking this board to ask, to let me ask the question.
I personally think that our charge here could be wrong, to decide if there was a decision made. And based on what has been submitted to us, I don't know employment rules and things of that nature, but I'm not sure that this board, as a representative of the town, legally has the right at this point to ask that question. And I'm not an attorney, and I'm sitting here making those comments based on how I feel and what I've read and understood here. There's the rest of the other 4 members of this board may disagree with me totally. But at this point, that's my comments. We need some input here.
Yeah, and I would say we don't represent just the town, we also represent the town people. I mean, we're kind of the liaison of sorts, so we don't just represent the town of McClure.
Well, right.
So, in that
I
case.
stand corrected.
Well, I think that's important too.
Read page 120. Mr. Moore is saying you're comfortable that there's not a requirement that it be rezoned as a parking for the commercial facility.
Where are you on 120?
I'm in the,
Actually, it's on 119 too.
Oh, it starts down at
start at
119, okay.
119. And she's answering, not in accordance with our zoning,
That's Mr. Egan answering.
Mr. Egan answered. This is not Sheila's answers. These are another attorney's answers. Sheila in nowhere on here made the determination.
It does end with, yes, I want to make sure that we're squared away on that, says Commissioner Moore. Mike Egan says, okay, I'd be happy, before that says he'd be happy to look into it
But all
further.
of that is Mr. Egan talking. That is not Sheila talking. And he's saying, I will look into it to make sure. Sheila's saying, the questions that Mr. Moore is asking Sheila is, are you going to rezone it, and do we need to notify people? And Sheila's just quoting the requirements of the ordinance. So if the suit was brought against Mike, I'd say, yes, you have to.
Well, but so what about top of 118? You've got bottom of 117.
Okay.
Line 25, it says, is it now its own use? Does it need to also be included in the rezoning request? And this is a question, this is Mrs. Spicer asking in the form of a question, Ms. Spicer. And what we have come up with is that the zoning regulations recognize that is that if the only use of that property is an accessory parking area for another use, it's not in its own use. So that accessory use then is based on the that ordinance.
Well, on that
Off-site
same line,
parking.
if you go on down back on 118 there, where you stopped, if you go down to line 13, and it states that the regulations do allow off-site parking that extends in the residential district, but they're asking in this request, that's some of the exceptions that they're asking for.
But with each one of them, she's answering what our regulations state. She's not saying, yes, we're giving it to them.
Yeah, but everything we're talking about it on these two lots only has to do with parking. And so to me, there's been an answer somewhere, by somebody for it to be parking.
Well, that was done by the town council.
It
Was
was
that
done.
made in the conditional redistricting, the conditional district, or was that done in the original passing of the ordinance back in 92?
But if you go back and look at the email, she's saying that town council has the authority. She's saying, I don't have the authority to do that, town council has.
So, but how did parking end up on this spot? That's just my question.
That was my question also. And it goes in there, it says, well, it's not gonna be
I agree.
rezoned
So-
because Mr. Moore asked the question. It's in our packet.
And the reason that's important for me is because I just don't know the answer to it. That's, I guess, where, yeah, we need to make a decision, but did Sheila make that decision, or did the town council make the decision? Did town council make the decision in the conditional district rezoning, or was it done in the passing of the original ordinance? So the question is, who made the decision? Was the decision made by the staff member or by town council? If town council made the decision, was it made in the conditional rezoning, conditional zoning district, or was it done in the passing of the original ordinances? What I understand Mike Egan is saying is that it was done in the original ordinances, which we were directed to.
Well, there were two decisions. One was in enacting those regulations which allowed parking serving a commercial use to be located in a residential zoning district. That was one decision. And the second decision was the decision by town council to rezone the property and approve the list of standards and conditions that went with it. That was the second decision. They were the only ones that could make that decision.
And Sheila has no authority to make that decision.
No.
Well, I'm sorry, there's misinformation here. The two parcels in question, you can tell from the transcript, was not rezoned. It was not part of the rezoning application. There's no public hearing for those two parcels to change what was allowed on there. And I have a certified copy of the zoning ordinance. If you look at the section that he's referring to about parking, the standards for off-site parking in a residential area requires that the commercial district be adjoining and that the commercial use on that property be adjoining. And those are the standards. In order to change those standards, you would have to rezone or amend the ordinance to allow for it. Those two properties weren't part of the application. So she appeared to say to John Moore that you don't have to rezone it, the town council can just waive it. And that's an incorrect determination. And that's why, again, to cut through the smoke is, as we sit here today, would commercial parking be one of the permitted uses on that piece of property? And with all due respect about jurisdiction, there's plenty of cases that say with jurisdiction, when the court's trying to determine subject matter jurisdiction, that they can open up the record and take testimony, they can take documentary evidence. There's a lot that goes in for the court to determine subject matter jurisdiction, and it's not just the pieces of paper that Sheila might have turned in. With all due respect, the case law on subject matter jurisdiction allows you to open it up for additional information. And so, again, if you just asked her the question today, have you decided whether commercial parking would be allowed on those two pieces of property? If she said yes, because town council made that decision, well, we all know it wasn't rezoned. She's making a decision that the zoning ordinance somehow allows it without the property being rezoned.
They've made a lot of comments about the zoning ordinance. Mr. Justice has certified copies of the zoning ordinance. I would just ask that he hands them up if they're gonna make arguments and point you in aspects of it. And if the case gets appealed to Superior Court, it'll need to be part of that record.
I do have a certified copy from the town clerk of the zoning ordinance.
Motion or something. We need a motion. More discussion if that we need.
Let's have opinions. Let's poll each, I'd like to poll each person, and I'd like to have an opinion about where we're at here. We're at a standstill and a stalemate, and we need to do something, right or wrong, or, we need to do something. So, let's switch it up. Mr. Erickson, I'd like to start with you for this.
Sure. I'm confused because I hear that Mrs. Spicer has made a decision, and then I hear from the other attorneys that the town has made the decision and that they have the ability to waive it. I hear that from the other attorney that the town does not have the authority to waive requirements. So I cannot make a decision based on the conflicting interpretations that I'm hearing from the two different attorneys. Has the town council approved this? Have they granted acceptance of these parking lots?
Are you satisfied that we have the authority to make that determination?
I do not think we have the authority to make that determination.
Ms. Maringer?
Mr. Chairman, I'm looking at page 9 and 10, and Sheila goes through the whole section of telling them what our requirements are, and saying that, in essence, she can't make that decision, town council has to waive it. And then when I go back and look at the conversation between Mr. Moore and Sheila, and nowhere in there she actually made the decision. She stated what the uses of a parking lot is. She stated the requirements in our book of what a parking lot is. But she left it up to the board, to the town council to decide. Like I said, if it was Mr. Egan that Mr. Justice was discussing, I probably would say, yes, he has a case. But
Mr. Owensby?
I don't think we can hear something that she didn't make a decision on.
Mr. Owensby?
Well, I'm a little confused myself too from hearing one side and hearing the other side, and,
Well, I think we really, I'm not, I want you to finish that, but really, we've got to decide, did she make a decision? I think that's what we've got to decide from, did she make a decision? If,
well, would you
because
look at it,
we don't have the authority.
my question would be is, if the town council made the decision, then wouldn't she be, since she's an employee of the town, acting on behalf of the town, would she not be doing what she thought that the town authorized her to do, or?
She's advising.
She's advising
advising.
and enforcement.
She's advising and enforcement. She's advising what she, in her professional opinion, what our rules and regulations and books say. She's advising the council of that, so they can do their business. Mr. Butts?
Yes, I think Sheila made a decision.
You have to explain.
Based on 118, where it says what we've come up with is that the zoning regulation recognizes that if only use of the property is an accessory parking area for another use, it is not its own use. That is, I believe that's a decision, that's an interpretation of the ordinance.
And I believe I'd have to agree with him based on that.
Okay. Take a 5-minute recess.
What I think we probably need to either put it to a motion, whether you're gonna grant their motion to dismiss based upon lack of a decision on Sheila, yes or no, and we've already got a couple of votes, but there's been no formal motion to it,
Okay.
but I don't think we need to take a recess. I think we just need to put it to a vote right now.
Yeah, I make the motion that we address the first part of the motion to dismiss of whether or not that there was indeed a decision made by town staff on off-site parking
By Sheila.
by Sheila, town staff, Sheila, Ms. Spicer, yes.
So that's your motion that you think she did make.
No, okay, so the motion would be, yeah, there you go. So the motion would be that Sheila Spicer did make a decision to allow commercial parking at that parcel.
In the residential district.
In the
of
residential district.
Parcels identified in the record.
Somebody getting that?
As clean as that all was.
Okay, you've heard David's motion for vote. That
Right. So the motion is that she did make a decision.
okay? Do I hear a second for that?
Second.
Seconded by Mr. Ormby. Okay, Mr. Manager, how do you vote?
I vote no. I don't think she did, and because it states what we've come up with. We is not I.
Okay,
We're discussing Sheila.
okay. Mr. Butts?
I vote yes. I vote yes, as stated earlier.
Mr. Owensby?
I vote yes, as I did earlier.
Okay. Mr. Erickson?
As I stated before, I cannot make the decision that whether she made a decision or not, so I would vote no.
Okay. So we have 2 yeses and 2 nos. I guess that comes to me. And I feel like I have to vote no in this situation. I do not think that we're qualified to make that decision and determination here. So I vote no, that she did not make a decision.
That passes that, or that motion doesn't pass, so
Should word the motion different?
yeah, so then there probably has to be a motion
Another
granted
motion.
to dismiss, to grant their motion to
Grant their
dismiss.
motion to dismiss. Someone like to make that
I'll
motion?
make the motion to grant their motion to dismiss.
Okay, you heard Ms. Manager make the motion to dismiss, to accept their motion to dismiss. Do we have a second?
There's no motion.
Okay, I guess that motion didn't get a second, so it's,
If not, that one,
someone else have another motion they'd like to make?
Can't you second?
I don't know, can I second it?
yeah, you didn't make the motion, so you can second it.
I'll second that motion, I'm sorry. Thank you.
I just, not gonna.
I didn't think I
second the
could,
motion.
I didn't think I could, so.
So I would take a vote.
So now we have a vote. All those in favor of accepting the motion to dismiss, please say aye. Oh, I'm gonna do it this way. Melvin, you, yes or no on voting to accept the motion to dismiss?
I vote, no.
Okay. Mr. Erickson,
I vote yes.
Mr. Butts,
No.
Ms. Manager,
Yes.
and I also vote yes to accept their motion to dismiss. So, what's our next,
5-minute break?